Indian polity. Generally, we will start with Indian constitution. The major part of Indian polity is Indian constitution and constitutional machinery, constitutional institutions and functionaries. That all we will study. First, what do we study in Indian polity? The basic characteristics of Indian constitution, the foundations of Indian political setup. India is a parliamentary form of government. India is a Indian political setup relies on parliamentary setup. We go with parliamentary form of government, where real powers lies with Council of Ministers headed by the Prime Minister. Real powers lies with Council of Ministers headed by the Prime Minister. Parliamentary form of government is different from presidential form of government. In presidential form of government, all powers are centralized with the president. President is a real powerful man. In presidential form of government, the real powers are enjoyed by the president. Example, American President Donald Trump. If you see in the presidential form, president is very powerful. In the parliamentary form, the prime minister is powerful. For example, Britain have a parliamentary form of government. America has a presidential form of government. And presidential form of government, president is powerful. Parliamentary form of government, prime minister is powerful. Indian President Ramnath Kovind, Mr. Ramnath Kovind, symbolically is the head of the nation. Head of the nation or head of the state is president in India. Head of the nation is also called as head of the state. Head of the government is prime minister. Head of the nation is president. Head of the government is prime minister. Okay. See, Narendra Modi enjoys powers, real powers in India. Whereas Ramnath Kovind, though head of the nation, enjoys only symbolic powers. So, American president, Indian president, just compare. Okay. So, Trump have real powers. Indian president do not have real powers. India is a republic. What do you mean by republic? Republic means where the head of the nation is elected by the people. The head of the nation is elected by the people. I just told you who is the head of the nation. Head of the nation is president. President is elected by the people. Indian president is elected by the people indirectly, not direct election. For Indian president we don't have direct election. Will you vote for Indian president? No. But our MLAs and MPs vote for Indian president election. Okay. So, India is a republic. Republic means where head of the nation is elected by the people. America is also a republic. American president is also elected by the people. Whereas Britain is a hereditary monarchy. Britain is a hereditary monarchy. Britain is not called as a republic because queen's son will become king. Okay. Their children will become kings and queens and they will be hereditary heads. There won't be election for the king or the queen. The head of Britain is king or queen and the head of the Britain is a hereditary monarchy position. They will get automatically by virtue of their blood. There is no election. India is a republic. America is a republic. Whereas Britain is not a republic. Okay, clear? Next. India have a written constitution. WRITTEN. Indian constitution is in the written form. Indian constitution is in the written form. American constitution is also a written constitution. Australian constitution is also written constitution. The constitutions for which there is a text, that is called written constitution. British constitution is mostly unwritten. The example for written constitutions, India, America, Australia, these are all written constitutions, whereas British constitution is mostly unwritten constitution. India relies on federal model. Federal, federal model. What do you mean by federal model? Listen. There are two types of constitution in the world. Unitary constitution, federal constitution. There are two types of constitutions in the world. Unitary constitution, federal constitution. If all powers are centralized in one government, that is the central government, and states act like small units with less powers, with very less powers, that is called unitary. If all powers are concentrated or centralized in the central government, where states have very minimal role, units have very minimal role, that is called unitary constitution. That is called unitary constitution. Whereas if there is a division of powers between center and states, in the domain certain important issues, center will exercise its powers. In certain important issues in the local level, state will exercise its power. If there is a clear cut division, that is called a federal constitution. That is called a federal constitution. For example, America is a federal constitution. Britain is a unitary constitution. In Britain, all powers are centralized in one government. In America, there are distribution of powers between center and states. In America, there is distribution of powers between center and states. In India, India is also comes under federal model. India also comes under federal model. But India is not a strict federation like America. India is not a strict federation. Though we will give states an autonomy, but under certain conditions, center will dominate the states. So some thinkers say India is a quasi-federal state. QUASI. India is a quasi-federal state. Professor K.C. Ware, WHEARE. K.C. Ware said India is a quasi-federal state. It looks like, what is quasi-federal? It looks like federal but not a true federal. Quasi-federal means it looks like federal but not true federal. That is called, Professor K.C. Ware said India is a quasi-federal state. Okay. So, Britain is the example for unitary, America is the example for federal, India is also almost federal, but there is a centered domination in certain issues. And next is, in India we have single citizenship. Throughout India, same citizenship. We are Indian citizens. We don't have separate citizenship like Telangana citizenship, Andhra citizenship. Except to the state of Jammu Kashmir, citizenship is same throughout India. We have single citizenship. Whereas in America, there is double citizenship. There is double citizenship. It means a citizen of America is a citizen of USA and citizen of particular state. For example, you are living in Texas. You are citizen of USA and citizen of Texas. Whereas in India, we have single citizenship except to the state of Jammu and Kashmir. Okay. And in India, we have single integrated judiciary. We have at the apex, at the top, a court called Supreme Court. Supreme Court is also called as apex court. APEX. Supreme Court is also called as apex court. Under Supreme Court, we have high courts. We have 24 high courts. Under high courts, we have district courts. Under district courts, we have CMM courts, Judicial First Class Magistrate Court, Judicial Second Class Magistrate Court, Munsif courts, all these courts. So, the apex court is Supreme Court. We have single integrated judiciary. The judgment given by the Supreme Court is binding on all the lower courts. All the lower courts in India should follow the judgment given by the Supreme Court. For example, in Sabarimala case, recently Supreme Court gave a judgment. The judgment should be followed by all the lower courts. Even Kerala High Court. If you don't want the judgment, if you don't want to follow the judgment, you can file a revision petition. But you are not supposed to ignore the decision or do against the decision. You are not supposed to. Okay, Sabarimala decision. So the judgment given by the Supreme Court is binding on all the lower courts. In India, we have a concept called judicial review. In India, we have a concept called judicial review. What do you mean by judicial review? The Indian judiciary have the power, the High Court and Supreme Courts have the power to decide the constitutional validity of any law made by the Indian Parliament or state legislature. For example, if our state legislature makes a law which is against the fundamental rights, or if Indian Parliament makes a law which is against some basic issues of the constitution. For example, you have right to life. If Parliament makes a law taking away right to life, or you have right to freedom of religion. If Parliament makes a law taking away your freedom of religion, then Supreme Court can apply its doctrine of judicial review and can say the law is null and void. The law is not valid. Null and void means the law is not valid. If Parliament makes any law or state legislature makes any law against the constitution, then the Supreme Court have the power to, Supreme Court and High Courts have the power to decide that law is invalid. This power is called judicial review. The power of judiciary to review the laws made by the Parliament and state legislature, whether they are inconsistent with the constitutional principles or not. If the judiciary feels that they are not inconsistent with the constitutional principles or not, then the judiciary can strike down it. This is called judicial review. Okay, we have borrowed this idea from America. In America also we have judicial review. Idea of judicial review you have borrowed from America. Okay, just remember there is a concept called judicial review. Apart from that, in our constitution we also have fundamental rights. Fundamental rights we have 6. Part 3 of the Indian Constitution deals with fundamental rights. Part 3 of the Indian Constitution deals with fundamental rights. We have 6 fundamental rights. Okay. When our Constitution have come into force, we have 7. We have 7. In the beginning we have 7. Now we have only 6. Right to property, a fundamental right, was taken away as a fundamental right. Right to property as a fundamental right was taken away as a fundamental right. Now it was only a legal right. Now it was only a legal right, but not a fundamental right. Right to property was taken away by 44th Amendment 1978. Right to property was taken away by 44th Amendment 1978. So up to 1978, Indian Constitution came into force on January 26, 1950. January 26, 1950 to 1978, up to 44th Amendment 1978, right to property has been taken away as fundamental right. After 44th Amendment 1978, right to property has been taken away as fundamental right. Now how many fundamental rights we have? They have 6 fundamental rights. We have 6 fundamental rights. Right to equality, right to freedom, right against exploitation. Never say right to exploitation, it is right against exploitation. So the first fundamental right is right to equality, second fundamental right is right to freedom, third fundamental right is right against exploitation, fourth fundamental right is right to freedom of religion, fifth fundamental right is cultural and educational rights, sixth fundamental right is right to constitutional remedies. Right to constitutional remedies. How many fundamental rights we have? 6. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. REMEDIES. We have 6 fundamental rights. Remember basic thing about fundamental rights. They are in the part 3. When fundamental right is violated, you can go to court. Fundamental rights are enforceable. When fundamental right is violated, you can go to court. That is, fundamental rights are enforceable. After fundamental rights chapter, we have directive principles. After fundamental rights chapter, we have directive principles of state policy. This is part 4, article 36 to 51. Article 12 to 35 is fundamental rights, part 3. Part 3, 12 to 35 is fundamental rights. Part 4, 36 to 51 is directive principles. Directive principles of state policy. Remember, when fundamental rights are violated, you can go to court. When directive principles are violated, you cannot go to court. When fundamental rights are violated, you can go to court. When directive principles are violated, you cannot go to court. This is the basic difference between a fundamental right and a directive principle. Part 3 and Part 4. Part 3 rights are enforceable. Part 4 are not enforceable. After directive principles, we have fundamental duties. For us, in the original constitution, we don't have fundamental duties. In the original constitution, we don't have fundamental duties. Fundamental duties are added by 42nd Amendment 1976. During emergency, there was a big amendment, biggest amendment, large amendment, 42nd Amendment. Fundamental duties are added by 42nd Amendment 1976. They are not enforceable in court. Are they enforceable in court? No. If they are violated, you cannot go to court. That means, can the government complain on you because you have not done fundamental duty A, fundamental duty B? No. But they are very important. I will explain you in future. So, after that we have President, Vice President, Prime Minister, and then we have Judiciary, Union Judiciary. Then State Government, that is Governor. See, the Governor in the Indian setup is neither directly elected nor indirectly elected. Governor is appointed. President is indirectly elected, whereas Governor is appointed. Governor is considered as an agent from the center to the state. Agent from center to the state. And symbolically, in the state level, the head is Governor. But in the state level, the real powers are with Chief Minister. And you have high courts, you know that. After that, we have certain constitutional bodies. What are constitutional bodies? The bodies which are created by the constitution are called constitutional bodies. Like Attorney General, like Comptroller and Auditor General. Attorney General, Comptroller and Auditor General. Like we have Election Commissioner. Election Commission of India is a constitutional body. Public Service Commissions are constitutional bodies. Finance Commission is a constitutional body. So, the bodies which are created with the constitution are called constitutional bodies. Apart from that, in the constitution, CBC is not a constitutional body. CBI, CBC, they are not constitutional bodies. The bodies which are originated from the constitution are called constitutional bodies. Election Commission, Attorney General, Public Service Commission, Comptroller and Auditor General, Finance Commission, they all come under constitutional bodies. So, this is how Indian Constitution is made. Every time the last article is 395. We have 103 Constitutional Amendment Acts till date. 103 Constitutional Amendment Acts. Constitutional Amendment Bill is different from Constitutional Amendment Act. Remember, Constitutional Amendment Bill is different from Constitutional Amendment Act. All amendment bills will not become acts. All amendment bills will not become acts. Okay. Bill is different, act is different. All bills will not become acts. So, we have 103 acts, Constitutional Amendment Acts. So, we have 395 articles. The last article is always 395. Then you may get a doubt. See, if you amend, you add new things. When you add new things, why don't article number increase? Article number will not increase. What do? They add A, B. For example, they have added right to education a fundamental right. They have added 21A. 21A. They have added within the articles, insert relevant articles with A, B, etc. In the relevant articles, they insert A, B, those things. They don't add new articles. Okay. Within the existing article, they will insert 395 articles and 12 schedules. Our constitution have 395 articles and 12 schedules. Our constitution also have certain special provisions with respect to tribals, scheduled tribes, scheduled areas, and special protection to many states like Nagaland, etc., Assam and all these states. And it also empowers the local self-governments. 73rd amendment is for panchayats, 74th amendment is for municipalities. 73rd is for panchayats, 74 is for municipalities. Apart from that, we have article 368. Article 368 deals with amendment to the Indian Constitution. 368. And we have special article for Jammu Kashmir. So, special status to Jammu Kashmir. Article 370. 368 amendment to the Constitution. 370 is special status to Jammu and Kashmir. So, we have total 395 articles, 12 schedules. 12 schedules. Okay. This is the basic framework of Indian Constitution. Basic framework of Indian Constitution. Done.